Have you ever really thought about what happens when someone gets hurt on another person's property? I mean, who's actually responsible? Well, that's what we're diving into today with something called occupier's liability. It's this whole area of law that, believe it or not, affects pretty much all of us. So let's break it down.
Right, let's get straight to it. This is the big question, isn't it? If someone trips over a rug in your living room, are you suddenly on the hook for all their medical bills? The short answer is, well, it's not that simple. It really all depends on who that person is and what they were doing there in the first place.
Okay, let's paint a picture to make this super clear. Imagine a young kid, we'll call him Paul, who sneaks into a farmer's orchard to grab an apple. He hops onto a wall that looks totally fine, but it's not. The whole thing crumbles, and Paul gets hurt. Now, who's to blame? The farmer? Paul? This is exactly the kind of real-world mess we're going to untangle.
So yeah, these everyday accidents can spiral into some pretty complex legal territory. But thankfully, we're not just guessing. There's actually a specific legal framework, a rule book, if you will, that tells us how to handle these exact situations. And that rule book is the Occupier's Liability Act of 1995. This piece of law was literally created to sort out who's responsible for what when it comes to safety on a property. It's going to be our guide to figuring out what really happens with Paul and that farmer. All right, so to really understand this rule book, we've got to get our heads around two absolutely key terms first: occupier and premises.
First up, the occupier. Now, the magic word here is control. The occupier is not always the owner. It's the person who has control over the property. You know, the one who can say who comes and goes. The one who's in charge of making sure things are safe.
And what about premises? You might be surprised. The definition is incredibly broad. We're not just talking about a house or a field. It can be land, water, buildings, and even things that move, like cars, buses, or boats. Yeah, seriously. Okay, now that we've got the lingo down, here's where the act gets really interesting. It takes every single person who steps foot on a property and sorts them into one of three, and only three, distinct categories.
And here they are, the big three: visitors, recreational users, and trespassers. The amount of responsibility an occupier has, what the law calls their duty of care, is totally different for each of these groups. This is the whole ball game right here.
So let's kick things off with the group that gets the highest level of protection under the law, the visitor. So a visitor is basically anyone you've invited onto your property, whether you said it out loud or it was just implied. Think about it. Guests at your house party, customers walking into a shop, even the delivery driver bringing your food. For these people, the occupier owes a duty of reasonable care. That just means they have to take reasonable steps to keep them safe from any dangers. So what does reasonable care look like in the real world? Let's check out a case. In 2017, an elderly woman who had a fear of escalators fell on one at Dublin Airport. She wasn't holding the handrail and later argued that there wasn't a clear enough sign pointing to the elevator. So the big question for the court was, did the airport fail to take reasonable care? And the verdict? The Court of Appeals said no. The airport was not liable. They basically found that an escalator isn't some kind of unusual or hidden danger. The airport did what it was supposed to do. It's a great example that reasonable care doesn't mean you have to create a world with zero risks, especially when those risks are pretty obvious.
Okay, so that's visitors covered. Now let's get into the other two categories, recreational users and trespassers. And as you're about to see, the law treats them very, very differently.
So a recreational user is someone like a hiker or a person fishing who's there for fun and isn't paying. A trespasser, well, they're on the property without any permission at all. But here's the kicker. The duty of care owed to both of them is exactly the same, and it's much lower than for a visitor. The occupier just has to make sure they don't injure them on purpose or act with reckless disregard for their safety.
So what in the world is reckless disregard? Let's look at another case to figure it out. A woman walked through a gap in a fence, followed a path right to a cliff edge, sat down for a bit, and then tragically she lost her balance and fell. She argued that the broken fence was reckless disregard on the part of the landowner.
But the Supreme Court disagreed. They found the occupier was not liable. And the reason why is crucial. The danger of a cliff edge is obvious. This case really drives home a key point. The law expects us to take some personal responsibility, especially when we're facing a risk that's staring us right in the face.
But, and this is a big but, the rules can change when children are involved.
In a really important case from before the 1995 Act, a young boy climbed through a hole in a fence into an electrical station and got seriously hurt. Now, even though the danger was obvious, the court said the company was liable because the broken fence acted like an invitation for a child. This shows that occupiers have a much bigger responsibility when there's a danger that might attract kids.
All right, we've got the rules, we've looked at the real-life cases. Now it's time to bring it all home and go back to our story from the beginning.
So let's solve the case of Paul and the wall. Step 1. What is he? He's a trespasser. No permission. That means the duty is not to act with reckless disregard. Step 2, and this is the most important part, the farmer knew the wall was unstable. It wasn't an obvious danger like a cliff, it was a hidden one. Step 3, the farmer did nothing about it. No sign, no repair. So step 4, knowing about a hidden danger and doing absolutely nothing, that looks a lot like reckless disregard. So in this case, yeah, the farmer's probably liable.
But the conversation doesn't stop there, because this area of law isn't set in stone. Far from it. There is a constant debate going on about where to draw that line between a property owner's duty and our own personal responsibility.
In fact, there are proposed changes to the Act being discussed right now. They're looking to create a standard that's more practical and proportionate, which might make it tougher to sue. There's also a bigger focus on whether someone willingly accepted a risk. A lot of this push for change is because of concerns about things like rising insurance premiums and this idea of a compensation culture. It's all about trying to find that perfect balance.
And that really leaves us with the ultimate question, doesn't it? In a world that's just full of risks, some you can see and some you can't, where does a property owner's duty to protect us end, and where does our own responsibility to look out for ourselves begin? That's the question the law, and all of us really, will keep trying to answer.